Hey everyone, David Miklas here. Now, some of you may be wondering what's with the recent push to hire convicted felons. During the first week in April 2019, I saw a post from SHRM that said, quote, 700,000 people get out of prison each year. Let's hire them, end quote. As an employment lawyer who represents Florida employers, I felt that this social media post would be used in trials in the future against employers when one of these convicts does something bad to a customer or a coworker. I wondered whether Florida employers might be a little bit confused as to what they should do. I looked into what could be the basis of this April 2019 SHRM posting, and I saw that about a year earlier, back in May of 2018, SHRM published a document called Workers with Criminal Records. In that document, it discussed a nationwide survey of HR professionals and their opinions towards workers with criminal records. Now, contained in that SHRM document is the statement that every organization must decide if and how it will approach hiring workers with criminal records. In many cases, these important conversations have not yet taken place. So employers who choose to pursue this talent source need to understand how to manage both real and perceived risks of this hiring practice and must communicate their policies and practices to their employees. So, SHRM appears to recognize that there are risks to hiring convicted felons. That's good to know. So, where else can Florida employers look for guidance? Well, 7 years ago, the EEOC issued an enforcement guidance on the consideration of arrest and conviction records in employment decisions under Title VII. That 2012 EEOC guidance updated older EEOC material. So if you stumble across stuff on the internet such as the EEOC's 1987 and 1990 policy statements on this issue, or the EEOC's race and color discrimination compliance manual chapter that talks about this issue, those things were superseded by the 2012 EEOC guidance, which the EEOC announced was designed to be a resource for employers covered by Title VII and for EEOC investigators. So, let's look at some key aspects of that 2012 EEOC guidance. 1. Does that guidance prohibit employers from obtaining and using criminal background reports about job applicants or employees? No. The EEOC does not have the authority to prohibit employers from obtaining or using arrest or conviction records. The EEOC simply seeks to ensure that such information is not used in a discriminatory way. 2. How could an employer use this information in a discriminatory way? The EEOC guidance warns that there are 2 ways in which an employer's use of criminal history information may be discriminatory. First, the relevant law, Title VII of the Civil Rights Act of 1964, prohibits employers from treating job applicants or employees with the same criminal records differently because of their race, national origin, or another protected characteristic, which is called disparate treatment discrimination. Second, the law also prohibits disparate impact discrimination. This means that if criminal record exclusions operate to disproportionately exclude people of a particular race or national origin, the employer has to show that those exclusions are job-related and consistent with business necessity under Title VII in order to avoid liability. Number 3, how would an employer prove job-related and consistent with business necessity? Is it burdensome? Well, the EEOC tells us that proving that an exclusion is job-related and consistent with business necessity is not burdensome. The employer can make this showing if, in screening applicants for criminal conduct, it does 2 things. 1, considers at least the nature of the crime, the time elapsed since the criminal conduct occurred. Did this happen 2 years ago or 20 years ago? And the nature of the specific job in question. And 2, if the employer gives an applicant who is excluded by the screen the opportunity to show why he should not have been excluded. Number 4, maybe you're wondering whether the EEOC received input from other SHRM or other advocates such as the business community and the public on that topic. Yes. Prior to the EEOC issuing the 2012 guidance, representatives of employers, individuals with criminal records, and other federal agencies all testified at public EEOC meetings. The EEOC also received and reviewed approximately 300 written comments from members of the general public and stakeholder groups. The stakeholders that provided statements to express their interest and concerns included prominent organizations such as the NAACP, the U.S. Chamber of Commerce, the Society for Human Resource Management, SHRM, the Leadership Conference on Civil and Human Rights, the American Insurance Association, the Retail Industry Leaders Association, among others. The guidance specifically notes that several federal laws automatically prohibit employing individuals with certain felony convictions or, in some cases, misdemeanor convictions. For example, those who work at a port of entry, working for a private prisoner transport company, working as a federal law enforcement officer, and when a convicted felon is prohibited from possessing a firearm, which excludes those folks from a wide range of jobs that require such possession. Now, when the EEOC issued the 2012 guidance, it included some employer best practices, such as when asking questions about criminal records, limit inquiries to records for which exclusion would be job-related for the position in question and consistent with business necessity. Now, if you missed a part of this video or if it got confusing, no problem. Just replay the video. Hope this helps. Have a great day.